Mr. Hugo.
Good morning again, Edward Hugo of Hugo Parker for defendant and respondent Irigoyen Farms. The trial court correctly granted Irigoyen Farms' motion for summary judgment, expressly finding that the Federal Aviation Authorization Administration Act, quote, expressly preempts negligent claims against a broker and its hire, citing Cregan versus Walmart Transportation. The key at this point in time is simply judicial interpretation of the act and its safety exception. As to the act, it's to be interpreted broadly, just like the Airline Deregulation Act it was copied from. And with regard to the cases supporting that, I'm going to pull up Dan's Used Cars, not Car Wash, versus Pelkey, which is a 2013 U.S. Supreme Court case at 569251. Also, Roe versus New Hampshire Motor Transport. And finally, Morales versus TWA. Morales versus TWA makes it clear that, quote, state enforcement actions having a connection with or reference to carrier rates, routes, or services are preempted. That's about as broadly as you can write a sentence. It further holds preemption occurs even if a state's laws' effect on rates, routes, or services is only indirect. Here, services include shipping services. That is the issue. It's a 100% issue. And counsel, at the end of his argument, when he was talking about duty, what did he just tell you? He referred to duties under the transportation industry. That's why we're here. The transportation industry is shipping. That is why the federal preemption 100% applies. And we're done. But let's go to the safety exception. Here, the judicial interpretation is exactly the opposite. It's section 14501C1, and it requires a narrow interpretation of, quote, with respect to motor vehicles, close quote. And you nailed it, Judge, 100%. There is no defect in the trailer or the rig or the tires. Not at all. And if we look at the next section first, and I'm taking it a little bit backward, it's section 14501C2. It makes clear that this section preserves, this is important, a state's authority, quote, to impose highway route controls or limitations based on the size or weight of a motor vehicle or the hazardous material of the cargo, etc. That is where the state retains control, safety of the motor vehicle. It does not retain control over indirect shipping requirements or actions. And that's what we're talking about here. That is why the safety exception does not apply. The third and last point for me to discuss is the issue of duty. And we cited a case that's pretty much perfect here. It's the Hill Brothers Chemical case versus Superior Court that talks about an entity hiring an independent contractor to ship. Here, unlike Hills Brothers, we are 4 levels away from the shipping activity. We're not supervising the driver. We're not training the driver. We're not involved with the driver at all. And counsel, when he told you, if you look at these logs and note that the driver wasn't sleeping, who's that on? It's the person who retained the driver and should be supervising the driver, not somebody 4 levels away who hired a broker and ended up getting a driver and is running a farm. That's how far away we are from a duty. Not everybody in the world has a duty to prevent everybody else from doing something that's wrong or a mistake. It's very simple in this case. The Irigoyen Farm had no duty whatsoever. That's why the lower court's opinion should be upheld. If the panel has no questions, and I see none, I'm going to gift the remaining time to co-counsel. Thank you very much.
Thank you, Mr. Hugo.